A very good morning to one and all. Welcome to the seventh episode of Me-Arcone Queing, proudly powered by the Institute for Alternative Dispute Resolution, an organization dedicated to resonating peace, rebuilding trust, dialogue as the path to resolution. I'm your host, Sahil Yadav from National Law Institute, University, Bhopal, and it's an honor to guide you through today's discussion on ADR with a special focus on mediation. Before introducing our distinguished guest speaker, I would invite our founder of NADR, Dr. Deepika Saini, to welcome the guest.
Hello.
Yes, ma'am.
Hello, Mr. Barry Leon. Thank you very much for accepting the invitation. And I think your expertise, your experience will add on the new perspective towards the, alternate dispute resolution. So thank you very, very much for the, acceptance of our invitation.
Well, thank you for inviting me, and I've been very impressed with how organized everything is and all that you're doing. So I'm delighted to be a part of it, and hopefully I can say some things that will be of interest to the people who watch your podcast.
Absolutely, absolutely.
Sure.
All right, ma'am. So may I continue?
Thank you very much. Yes, please. Thank you very much, Mr. Barry Leon.
Thank you.
Pleasure.
All right. Today, we have as our guest the Honorable Barry Leon, an independent international mediator and arbitrator. He is affiliated with 33 Bedford Row Chambers, London, Arbitration Place, Canada, and Caribbean arbitrators. From 2015 to 2018, Mr. Leon was the presiding judge of the British Virgin Islands Commercial Court, part of the Eastern Caribbean Supreme Court. Until 2015, he was a partner and head of the International Arbitration Group at Purley Robertson Hill and McDowell LLP in Canada. And until 2009, he was a partner and for many years coordinator of the litigation and dispute resolution practice at Taurus LLP in Canada. He obtained his law degree from University of Toronto, an MBA from the Richard Ivey School of Business at Western University, and a BA in political science and economics from University of Alberta. Sir, as you asked me, in fact, were insistent about that I call you by your first name, Barry. So with permission, I will do so. Thanks a lot. And in today's podcast, I would like to discuss with you mediation and in particular your experiences and your thoughts on mediation. So with your permission, we would like to begin. All right.
I'm looking forward to talking with you about mediation. So fire away with your questions.
Thank you, sir. So Barry, I am very curious to know that you have had a remarkable career spanning roles as a partner at two leading Canadian law firms, a judge of the Eastern Caribbean Supreme Court, and now an independent mediator and arbitrator working internationally. What got you interested in mediation, and what work did you do initially in the field? What are your thoughts?
Well, I was thinking back, and I think the first contact I ever had with the word mediation or the concept of mediation was many years ago when I took a summer course at Harvard University on negotiation. And there were no mediation courses at that time. This was taught by Professor Roger Fisher, who was the dean of negotiation and really invented the modern way of thinking about negotiation and mediation. And at the time, I was interested in the negotiation part. It's a great book that he and his colleagues, he's written several books, but Getting to Yes is a book that is well worth reading. It's an easy read with great stories, but a lot of informative concepts about negotiating. And then on the last day of the course was mediation. And Roger, and I came to know him over the years later, talked about mediation, and that really got it into my head that mediation is assisted negotiation, and that's the essence of what it is. And so in the years when I was practicing law, doing commercial disputes, it was really the negotiating part that was of most interest, and people rarely mediated. their disputes. They would negotiate settlements or try to, but it was only over the years that, at least in Canada where I practiced, but I think in a number of other jurisdictions, that commercial disputes started being mediated in the last couple of decades, and even then, it's been slow growth in some areas.
Agreed, totally agreed. Having said that, you have such a great experience and decades of experience, in fact, in mediation. So, what do you see as the primary role in the act of mediation? As a mediator, what do you think are the primary functions of being a mediator?
Well, the primary function is really the one that I just mentioned, which is assisting the parties in their negotiation. Now, that's a pretty broad way to describe it.
Absolutely.
But there's a lot of confusion, even among senior lawyers, and still the difference between arbitration and mediation. The terms just aren't well understood. So mediation is assisted negotiation. The two parties, or more than two parties, are negotiating. And they could negotiate on their own and often do. And where a mediator comes in is to help with the process. So the primary role is to keep the negotiation moving forward in a constructive way, to help the parties get through roadblocks, whether it's personalities, and we'll talk about some of these things, I'm sure. But if you think of any negotiation, whether it's a real dispute between litigating parties or just in your life, emotions get in the way, pressures of time, pressures of other things. And then you get lawyers whose often their main focus is the court case or the arbitration and the legal issues. And disputes often involve a lot more than who's right and who's wrong, or even if we could predict with certainty, which we can't, whether a judge or an arbitrator would decide one way or another. I like to say, if you and I have a dispute, your lawyer is going to tell you you've got a 60% chance, and my lawyer is going to tell me I've got a 60% chance. And if you add it up, that can't be right. So, perspectives get hardened, and as the dispute goes on, people become overly committed to their own views and don't rethink. And so mediators help in all of those areas.
Mhm. I agree totally. So how does a mediator, because we know that apart from mediation, there is arbitration, there is litigation, and having judicial authorities. So how does a mediator different from arbitrator or a judge? What are the key differences that you can point out between them?
Well, the key difference is what your role is. So if you're a judge or an arbitrator, and the roles are very much the same, you're making a decision. You're listening to the parties, their evidence, and deciding. And you probably will be writing a written decision. And the pressures on you are different. You're paying attention beforehand. You're reading the materials. You're listening to the case, and then afterwards you're working on writing a decision. As a mediator, it's quite different. You don't make any decision. You don't do anything afterwards. If there's a settlement, if there isn't a settlement, you may follow up. So your work is in advance, getting ready, getting the parties ready, and then it's as a judge or arbitrator, you sit there and you listen and you pay attention and you make notes, but you're not under the same pressure to perform. Counsel are under pressure to perform. But as a mediator, you're under constant pressure. The parties may be in separate rooms. They'll be talking, they'll get a break. As a mediator, you don't get a break. You're constantly thinking, assessing, what do I do next? Why did they do this? What should I do to help? So, that's the difference. And people, when they're hiring a mediator, often will look to a former judge. And some former judges make terrific mediators just naturally. I mean, mediators it's not a in a way, it's a personality, it's a common sense thing. And traditionally, people would go to the family elder, the village elder, and that person would help them settle. And so I think when you're looking for a mediator, you're looking for somebody who has the kind of attributes that's going to help that process, as opposed to somebody who may have been a great decider, but doesn't have the skills to be able to facilitate the parties' negotiation.
Indeed, indeed. So having said that, we have different types of mediation. One of them is commercial mediation. So I'm curious to know that is commercial mediation all about money, all about who is going to pay, which party is going to pay, how much to which party or to which counselor or mediator, or is it something even more about money, more than money? What do you think?
Well, I mean, mostly what I do is commercial mediation. And I use the term broadly because sometimes it'll
Yeah.
be employment and labor mediation,
Mhm.
uh, things relating to business people or businesses. And the what they're fighting over often is money. It's a damages claim, and that's how they see the world. That's how the courts or arbitration require you to see it. You have to put a claim in and say what you're claiming. And you can claim injunctive relief and that kind of thing. But essentially, you're fighting often over money. In a mediation, as a mediator, and I think as counsel in a mediation, you want to look at what is really going on with the other side and with your own client or with yourself. So what are your underlying interests? And this goes back to the negotiation course that I told you I took with Roger Fisher. Yes, you take account of the legal risks. What are the chances I'm going to win? What are the chances I'm going to lose? What are the chances something will go wrong in the presentation of the case? But there's also other reasons why people want to consider settling. Everything from avoiding publicity and maintaining privacy, not establishing a bad precedent, saving face, and it's particularly important in some cultures. Sometimes it's maintaining a business relationship. In the Caribbean, where I do some of my work, if you're in a construction business and you start having disputes with your general contractors, you're going to be in trouble because there aren't that many general contractors. It's not like India where it's a big country. So you need to think about that. And then there's the pressures. Can you sleep at night? Is this hanging over your head? Is this, if you're a business, is this on your books? Is it distracting your employees from their day job? Is it distracting you from their day job? If you're a senior executive being paid large sums of money and you're spending several days on a piece of litigation, if you translate that into shareholder value, it can be a lot of money. So all of those considerations should be in play. And a mediator's job, and in fact, the lawyer's job, is to help help your client, and as mediator, help parties and their lawyers to think about those considerations and to give them the weight that they're due.
Indeed, I agree entirely. So, as you've stated that there are certain essentials for mediation, what do you think is one or the other kind of misconception people have about the essentials of mediation or about the concept of mediation itself? Uh, because we can hear people speaking anything about ADRs, not knowing the real concept or missing on a few points. So, what do you think is it? What misconception is generally imbibed in the society?
Well, certainly one of the misconceptions is the one we just talked about, that people are just fighting over money or something like that, when in fact they're fighting over all kinds of other interests. Probably the biggest misconception that I mentioned earlier is what the process is, that the mediator doesn't decide. And that's a misconception on the street, so to speak. But also, lawyers in the beginning of a mediation And we'll talk a bit about later, I hope, the process of a mediation, but often there's no opening statement, or there will be mediation briefs where each side prepares for the mediator and hopefully for the other side as well, their story, what their case is about, but not just a legal case, but more than that. And if you're a counsel for a party in that situation, it's your one opportunity to be talking directly to the other side's client. In most jurisdictions, it's inappropriate for a lawyer to talk to the other side's client. In a mediation, there's your opportunity. There's your opportunity not to berate the person, but to explain or point out things that his or her lawyer might not have pointed out. Because the lawyer may be seeing the case too much in a legalistic way, or may have some misconceptions in assessing it legally. So, I think that's the biggest, or those are the biggest misconceptions around mediation, and is what the process is and how you can use it effectively as a party or as the party's lawyer.
Agreed, totally. So as we see that mediation is not just a practice which is practiced in USA, it's practiced in India, China, USA, UK, and many other countries of the world. So what is one thing that you can change if you are given the power to change one thing about mediation globally or generally, what would it be? What do you think is the necessary change?
Well, I think it's not so much about changing mediation, because I think mediation, mediators constantly learn, and you'll find on LinkedIn, if you're interested, discussions, mediators posting suggestions and comments, and then you'll find it lots of places. And I've been in discussions and trading ideas among mediators. What can you do if this happens or that happens? But I think the biggest change that's needed in some jurisdictions and is an understanding and appreciation that there is a role for mediation and that it should be encouraged. And so, in Ontario, Canada, where I practiced, there was, for the last 2 decades or longer, there's been in many areas mandatory mediation. That is, somewhere in the litigation process, the parties are required to mediate. And in other jurisdictions, people recoil at that idea. Like, how can you force people to mediate? Mediation is a voluntary process. And the answer is that you're not forcing them to settle, you're not forcing them to do anything more than engage in the process. And there's lots of reasons for it. It's in the party's interests. It's in the court system's interest. India and almost every other jurisdiction in the world has a huge backlog in the court system, and which is another reason why settlement makes sense. If you're going to be waiting for years for a decision, the world moves on. You don't have use of the money if you're going to be recovering. It's hanging over the parties' heads. And if witnesses disappear, forget, people even forget why they're fighting. And so I think the biggest change I would like to see is it becoming part of the culture from day one, in lawyers and business people, realizing that disputes are business problems. They're not, if you're in business, if it's a dispute at a personal level, they're personal problems, but the dispute shouldn't take on a life of its own forever. And so maybe it can't be resolved, but using mediation, considering mediation through the course of disputes is the change I'd like to see inculcated in the cultures of legal cultures, business cultures, in all the jurisdictions where it isn't already there.
True, agreed. Another interesting question I want to throw is that in your experiences, have you ever seen a mediation experienced or witnessed a mediation as a counsel or as a mediator or as a party, let's say, where you expected mediation to go in a particular manner, but it was completely turned? It was completely the opposite, or something drastically changed. Has it ever happened? Has it ever surprised you that way?
It happens all the time. It happens because the number of times a mediator will hear a party say, this case will never settle. And we're wasting our time, we're wasting our money. The parties are too far apart. They've been, whatever the reason is, and the case settles. And that's it may not it doesn't settle on the basis that one side throws in the towel and walks away. That's very rare. But the parties find a common ground. And what we were saying earlier, that it's not just about money. So they'll find things that they didn't realize. Sometimes it's a new business opportunity. I've been the distributor for your product, and we had a falling out. And through the mediation, you realize that yes, there was this falling out, and there may have been reasons for it, but neither of us are inherently bad people, and there's a business opportunity. And occasionally there's a new business deal that comes out of a mediation. So I think the biggest surprise is that so many cases settle that the parties and their lawyers don't expect will settle, and often the mediators don't expect will settle.
Well, that's quite interesting to know. And apart from that, so the ground reality of India is that people are very much emotionally charged in disputes. And this is, I think, very universal because we are Homo sapiens, we are humans. And in any jurisdiction, if there's a family dispute or a neighbor-related dispute, there will be emotions involved. So as a mediator, how do you manage that? How do you keep neutrality? And how do you coordinate those emotions which are there and present in the humans and the parties?
Well, you're right about family disputes, and business disputes can become family disputes because often it's two people who were friends and business partners.
Agreed.
And I've seen that kind of situation where they're fighting as if it was a family dispute. But particularly as a commercial court judge in BVI, the BVI companies are the joint vehicle where the parties come together. And so there'd be two or more business people from, you name the country, India, China, Russia, Brazil. And they've come together as partners. They're operating businesses somewhere else. And so the fight comes to BVI. And you see so many instances of families falling out in ways that are so sad, because often they've got more money than either of them, I'll say either, sometimes more than two, can ever spend in their lifetimes and leave to their children. But they're, destroying themselves, they're destroying their families, and not just destroying the business, but the families. The disputes take time, and before you know it, they're in their elderly age. Children have moved on. So, as a mediator, you need to figure out what's driving people, or try to figure out what's driving people. Use your authority, because you do have authority, persuasive authority. People will treat the mediator well, with respect most of the time, and use that to keep a constant eye on what's going on and try to de-escalate any tensions. Whether it's moving the parties into separate rooms, changing the topics, trying to figure out, important skill of a mediator is understanding people, figuring out people and what's driving them, and how to get them to react and get them to get through the emotion and the difficulty.
Well, that's very sad. And another question that, well, I got this fact to know this fact that in Ontario and Canada, the province, and in many other regions, the UK Supreme Court, for example, recently had this rule of mandatory mediation, where we can see that two parties or the legal counsel are said to engage, the parties are said to engage in mediation involuntarily. What is your take on it? Should it be voluntary? Should it remain mandatory? Many people claim that it is wrongly headed. What is your say on it?
I'm all in favor of what they call mandatory mediation, which is requiring the parties, if they're not doing so voluntarily, to come together and try to settle. And I think society has a reason for it, because it's a public court system, it's costing money. But I think it's just common sense, good business practice. And in arbitration, you can't require people to mediate, but you can encourage them to mediate and give them mediation windows, opportunities to. But in the court system, if it either under the rules requiring every case to be mediated, or if a judge sees that this is a case because of the circumstances, the amount involved, the amount they're spending on legal fees, to direct the parties to mediate. And I think that doesn't direct them to settle. And they may not settle, and they're entitled to have their case decided. So I think the more that we can get our mind around the idea of mediation being part of the dispute resolution process in the court system, the better.
Well, true. Well, just a short note that this meeting will automatically end in 6 minutes. So in case our conversation has to extend beyond that, we'll send you another link and you can join immediately for the rest of 5-10 minutes or what your time is taken. And coming to the next question that we have been constantly asking you about, how to resolve disputes, how to mediate. But what do you think about a strategy? Can there be a strategy formed where the mediators and mediations can ensure that the parties can avoid dispute instead of resolving them from the initial points, that they can avoid the dispute? There's no need of mediation up thereafter. What do you think?
And that's becoming a bigger and bigger area of interest. So, and in some industries, it's existed perhaps informally, but disputes don't just arrive in full bloom. The things start happening along the way, whether it's in a personal dispute or a business dispute. And so if it's a project, a construction contract, product development, you see things start going off the rails, and the people involved may be too close to it. They're emotionally involved. They start to blame each other, and it escalates. And so dispute avoidance has become an interesting area for mediators. And in some instances, parties, particularly in bigger projects where they can afford this, they would engage a mediator right at the beginning to follow along and to be conversant with what's going on in the project. And I've done that. You'd follow the project, there's no dispute, but you understand what's going on. And then something starts to happen, and one side or the other can engage the mediator and say, look, we seem to be having a problem with X. And so I think dispute avoidance has a big role to play. In business, it's harder in life, but if you're in a personal relationship and things are not going well, people go to a marriage counselor, they go to to get some advice, somebody to before things blow up. And so dispute avoidance, I think, is where mediator skills can be quite useful.
Agreed, agreed. Right. To continue with the next question, I want to ask you, Barry, that you were interviewed recently in a Canadian legal publication, which was 11th CEDR, that is, I think, Center for Effective Dispute Resolution Mediation Audit. And in that, it was found that the aggregate settlement rate of mediation was around 87%, in which 70% were for the initial mediations, which got settled initially in the first meet, whereas 17% of them was shortly after the mediation day. So about this higher rate of settlement, what is your take? What is your opinion on the same? What does this indicate to you?
Well, the way I put it when I was asked about it, and if you think about it, that with mediation, you've got better than an 85% chance of getting a result that's agreeable to you. Now, you don't usually have a better than 85% chance of getting a result that's agreeable to you in court. So it's an interesting way to look at it, and it makes a point, and that is that because mediation involves the things we've been talking about, other interests and other ways of finding a resolution, and because there is no end to a mediation, no decision other than a settlement or no settlement. And so if there's a settlement, that means both sides have agreed, and that means it's an agreeable resolution. So yes, of course, it may be that one side or both sides don't get everything they wanted, or it may be that they found a way to resolve it where they put, they expanded the pie, to use the negotiation term, and both sides came away with more than they would have gotten had they done well in court. So it's an impressive result. It's something that I think, going back to what we talked about before about mandatory mediation, it's a reason why parties should be interested in mediating, encouraged to mediate, and in public court systems required to mediate at an appropriate time and in an appropriate way. And this is the I think it was the 11th. Did I say it was the 11th mediation audit? But the prior one had similarly high results. And there's two. If you broke it down to what you said, there were 70% that settled in the initial mediation meeting, which is a pretty high result. And then it's interesting that another 17% settled shortly after the mediation day, which tells us a few things. One, that a mediation isn't a failure if there's only a partial settlement or progress towards a settlement. And secondly, that the parties shouldn't consider mediation a one-shot deal. And mediators shouldn't consider it a one-shot deal. Often mediators will follow up even if they're not hired to do it. And, I'll contact the parties and say, it's been a week, you came close, or you were struggling with this, whatever the situation is, can I be of further assistance? And I think it's incumbent upon the lawyers and the parties and the mediators to keep at it. And sometimes it's, it won't be shortly after. They'll come back months later and try again with more information on the table, with perhaps changed circumstances on their assessment of their cases. But it's a process. It's not a tick the box. We've done our mediation. Now we can get on to go to court, go to our arbitration hearing.
Yeah, agreed. So, what is the role of legal counsel? As we have heard the word counsel repeatedly, what is the role of legal counsel in mediation? And what do you think are the common mistakes which they may make in a session of mediation? And how can these mistakes be avoided by them?
Well, the role of counsel, in one sense, isn't any different. They're representing and advising their client. But the process is different. There's nobody they can convince other than the other side. So they're not arguing to the mediator. And some counsel will think that their job is to, you know, give a strong version of their client's case, get the mediator on their side. Well, you want the mediator to understand what your case is about and all the reasons why, arm the mediator with things to use with the other side. But you're not convincing the mediator of anything because the mediator can't do anything. So it's an opportunity, as I said earlier, to talk directly to the other side's client. I found out recently, apparently in Ontario, it's common practice that the mediation brief, which you give to the mediator, is exchanged with the other side, but it's not the case in California. And it's just no particular reason, it's just people don't do it. Well, why wouldn't you want the other side to see where you're coming from and advance the process? And so the role of counsel in the mediation is to help bring about a settlement that's in the client's interest, obviously, but to help the client get over the emotion, if there's emotion, to work with the mediator to develop options, alternatives, to work with the client and maybe the mediator to develop proposals for the other side. The lawyers, has an active role in the assisted negotiation process. The mindset should be we're trying to see if we can make a deal that is in our client's interest. Whereas in an adjudicative process, your goal is to try to present the case most effectively, to be as persuasive as possible to the person who's going to decide the case. So that's, I think, a fundamental part of the legal counsel's role in a mediation.
All right. So after this valuable answer, I'd like to pose my last question of today's podcast. That if we talk about the process of mediation, as we have discussed before, that we'll be discussing it soon, what are the main steps of mediation which take place? And can you just brief us about the same as it happens in your jurisdiction or generally in all the jurisdiction?
Sure. Most people haven't been in a mediation, so they don't know what happens.
Exactly.
And most people haven't been in an arbitration. Most people haven't been in court. They may have ideas from television, but that isn't necessarily reality. So, what will happen in the mediation? Well, what will happen before the mediation, put it that way, is the lawyer and his or her client should take a hard look at their case. And it's an opportunity to stand back and say, okay, when we started this case, we saw it this way. We're now further down the line. We've gotten more information. Where do we think we stand now? And as I said earlier, also the parties' situation may have changed in terms of their personal or business situation, the pressures, the need for a resolution. And secondly, it's a time to consider the going forward, the costs and the risks of going forward towards a trial, and the benefits, because maybe it will be beneficial. The term in negotiation that from the Roger Fisher methodology talks about is the BATNA, BATNA, best alternative to negotiated agreement. And so your BATNA may be going to court. You can't, that's your backup. But maybe have some other alternatives too that can be considered. So all of those things should be thought about going into the mediation. And then often the mediator will have a private conversation by agreement, but with each side. Usually maybe just with the lawyers to find out, okay, what's your take on this? What are the impediments to settlement? How can I be helpful to you? And I've had it where the person said, well, the problem isn't the party on the other side, it's the lawyer. He's being obstructive. So, it just arms the mediator with more information. And then the mediation begins. I said earlier, there often may be written mediation briefs for the mediator. They often will be exchanged and should be exchanged, I think, with the other side. And then the mediator, you'll start with everybody in the same, almost always with everybody in the same room. And people usually will be polite and occasionally not. Occasionally there's real bitterness. And the mediator will try to set the tone, set a constructive tone, set some ground rules, about not being abusive to the other side, about, one of the ground rules I like to get is try to get the parties to agree that before they walk out, they'll give me a chance to convince them not to. So you do that kind of housekeeping, and just all kinds of other housekeeping. Where are the washrooms? When are we going to take a break? What's the process going to be? And then sometimes there will be the process will continue together, but often there will be the parties will break out, and the mediators will then do shuttle diplomacy, talking to one side, talking to the other. Sometimes relaying proposals, sometimes testing the waters. Sometimes the parties will come back together again. And the mediator is working with each side to try to find out ways in which they can find a common ground with the other side and expand the options and so forth. And then if you get to a settlement, the mediator's role is just to make sure that each side has their own lawyer. The mediator isn't advising or documenting, but to make sure that before people leave, they have signed an agreement. So there isn't buyer's remorse and somebody trying to get out of it, or there isn't a dispute later as to whether they really agree. You want to get it down on paper. And part of the advice to the lawyers would be to show up at the mediation prepared for that. So have a draft of the settlement agreement that you hope would get signed, but obviously on a computer where you can make changes. Have everything you're going to need. If you're going to need a release or a consent to dismissing legal proceedings, have it all there so people can. And so that's the process. And the mediator is, constantly on the move between the two sides and trying to keep them busy, parties busy when he's not with them or she's not with them, considering their positions, coming up with alternatives. And so one other thing to mention is often there's people involved in the mediation who aren't in the room. I mean, you want to have and insist as a mediator that either the people in the room have the authority to settle, or at least everybody knows where the authority limits are, and so there's no surprises. You don't get to a settlement then find out, oh, hold on, we've got to get approval from somebody. But you may want to also have people available to your side, whether it's an accountant to do calculations, whether it's a senior management, whether it's an outside expert. So that's part of the mediation process too, and these days it's a lot easier to communicate with those people. And then at some point, if it's working, the parties will have come to their agreement. They'll document it, literally and figuratively shake hands and call it a day, and hopefully be satisfied that they've better off than they would have been by not settling.
Well, agreed. Due to positive time, we would rest the questions now, and that's all for today's podcast. And on behalf of Institute of ADR, I would like to sincerely thank you, Barry, and for sharing such valuable experiences and lessons and perspective on mediation, and the way you answered with patience, skill, and with empathy. We look forward to always stay in touch with you and connect with you. So thank you for joining us so much. And that's all for today's podcast. To our listeners, I'd like to say that thank you for being part of this conversation. And we hope you now have a deeper appreciation for how mediation can help to resolve conflicts and create opportunities. That's all for the episode of Me-Arcone Queing. Until our next podcast, stay curious, keep exploring, and continue pursuing knowledge. So thank you for tuning in. And thank you so much, sir, again, for being part of this conversation. It was a very pleasant conversation.
Well, thank you for inviting me. I enjoyed it, and I hope we will stay in touch.
Definitely, definitely. No doubt. Thank you. Thank you.